I'm Darren Kavanoky, founder of the Kavanoky Law Firm. If you've been arrested for a DUI in California and you gave a blood or breath sample that was over the legal limit, there's a good chance you received a citation that says you were charged with violating 2 sections of the California Vehicle Code. In this video, I'll explain each of them and why you were charged with both. The first section is Vehicle Code 23152A. This is the code section that makes it illegal to drive if you're under the influence of alcohol, drugs, or both. To convict someone of this crime, the prosecution must prove 2 separate elements beyond a reasonable doubt. First, that the defendant drove a vehicle, and second, that they were under the influence of alcohol, drugs, or a combination of the two while they drove. A person is considered under the influence if his or her mental or physical abilities are so impaired that he or she is unable to drive a vehicle with the same caution and care of a reasonable, sober person. What you'll notice here is that no particular alcohol level is required to convict somebody of driving Vehicle Code Section 23152A. If someone's a real lightweight, even a small amount of alcohol can lessen their abilities and put them at risk of this violation. Impairment is typically shown by things like driving pattern, physical signs, and field sobriety test performance. Alcohol levels can also be relevant to this analysis. While Section 23152A focuses only on the condition of the driver, whether they're impaired or not, Vehicle Code Section 23152B focuses on one thing and one thing only: whether, at the time of driving, the defendant was above or below a .08 alcohol level. The 2 elements that the prosecution must prove here, beyond a reasonable doubt, are, first, that the defendant drove a vehicle, and second, at the time they drove, the defendant's blood alcohol level was 0.08% or more. 23152B is a crime of body chemistry. This is the legislature saying, we don't care how well or poorly you drove, or how you were personally impacted by whatever you drank. We declare that it is a crime to drive above a certain level, period. Now, thankfully, because alcohol levels change over time, and because of enormous problems in the areas of forensic alcohol testing, it is possible to fight and win DUI cases even when the breath or blood tests say that somebody's over the legal limit at the time of testing. Above all, understand this: a conviction on either count, whether it's Vehicle Code Section 23152A or 23152B, means a DUI conviction on your record with all the direct and indirect consequences that flow from it. From all of us here at the Kavanoky Law Firm, I hope this helps.